be speaking about, is there a process to expedite resolution of the Ontario court system? I have some slides available, and I am an adjudicator, mediator, and a licensed paralegal. I wear a few hats under the legal umbrella. And sometimes we have to have it because, this is what keeps us, abreast of all projects and deliverables. I am also a private investigator, but I didn't really do private investigation because I wanted to become a private investigator. It really helps me try and manage some of the tasks that I have. As an adjudicator, I preside over minor traffic violations for the City of Toronto. So if you have a speeding ticket or a red light ticket, or you've parked next to a fire hydrant, I can help you navigate it. I can't help you in court, but I can certainly help you navigate through it. I'm also a mediator, accredited towards performing civil and commercial mediations, family mediation, workplace mediation, and I also do third-party facilitation. Now, third-party facilitation is a little bit different than mediation. We actually manage to have open discussions with, your vendors, suppliers, and other providers. I'm a licensed paralegal. My area of expertise is small claims court and the landlord and tenant board. I'm also a notary public and do a little bit of commissioning, and I also do the document review and drafting. So I'd like to start the presentation. I'd like to ask you if you could help me with this. What should you do when you are served with a statement of claim from small claims court? A, ignore it and hope it goes away. B, file a defense within 20 days. C, immediately pay the plaintiff without reviewing the claim. Or D, contact the court and request an extension without filing a defense. B. Perfect. You guys are good. So yeah, in the small claims court jurisdiction, you have 20 calendar days. And I'm saying that with some reiteration because people think it's business days, and it'll come before you know it and you've got a default judgment. So for those of you who are planning to maybe embark on a small claims process, once you file the statement of claim, if you're the plaintiff or the applicant, the defendant has 20 days to actually respond to it. If they do not respond to it in time, you can put in a notice of default judgment. Going on to the next one. What are your options if a friend borrows $1,500 and then another $500 and refuses to pay? A, take them to small claims court. B, hire a collection agency. C, send a demand letter. Or D, all of the above.
All of the above.
Great, thanks. You guys are good. Question 3, last one. A landlord is owed arrears for commercial property. What should they do? A, file an LTB application. LTB stands for Landlord and Tenant Board. B, pursue small claims court. And C, hire a debt collection agency.
LTB.
Anybody else?
A.
Okay. So it's actually not A, it's actually B. The Landlord and Tenant Board falls under what is referred to as Residential and Tenancies Act, which doesn't help commercial properties. Okay, so your remedies are very limited. Small claims court. I will talk about that a little bit more, but in small claims court, I'm sure most of you know, it's $35,000 limit, and maybe you can get some costs out of it. So common civil and landlord-tenant matters that I manage are under civil matters. I help with contract disputes, unpaid loans, damage claims includes personal injury, and defamation, which includes libel and slander. And now there is also cyber, so it could go under both. And then there's common landlord and tenant matters that I manage are unpaid rent, property damage and maintenance, eviction, and landlord wants possession of the unit. So two common processes, which is the reason I'm here today, is to describe for monetary compensation are small claims court and debt collection agencies, okay? So as I mentioned previously, a small claims court is best for cases up to $35,000, maybe a few costs here and there. It's a more structured and legally binding process, although it's a little bit laxed. And there is a huge opportunity for applicants and defendants to be self-represented. But if you go anywhere higher than a small claims court, it's highly recommended that you get legal representation. The results in enforcement judgments, so you can actually get some money out of it. But I'm going to let you know that where small claims court is concerned, the aim for small claims court is to settle the matter. So in event you are stuck by principle to get your entire amount back, there's a high likelihood that you're not going to do that, because the small claims court is hell-bent over settling your claim. So they'll start with the settlement conference, and then right to the point of trial, they're going to try and settle with you. That's the judges, okay? And then there are enforcement options. There are quite a number of enforcement options, which I can talk about, or you can come and see me a little bit later that I can do. But typically, common enforcement option is garnishing wages, lien on properties, and also ensuring that you have like an option where you can actually have an asset in trust that you can keep. So those are some of the enforcement options. However, when we talk about small claims court, we're talking of a 2-year backlog. So if you were to submit something today, then you're looking at something enforcement related about 2 years down the road, which it sounds painful. So the other aspect is versus a debt collection company. It's useful when debtors are unresponsive or difficult to locate. You can report debts to credit bureaus to leverage your supplier, vendor, or even your landlord or tenant's credit bureau credit scores. And it's faster, less expensive than court, but may recover a lower amount. So, you know, if you typically have something less than $5,000, that's where you would consider going to a debt collection agency. And then they typically charge anywhere from 10 to 50%, depending on whether your debt is less than 6 months or it's over a year, because the age of the debt really matters in this thing. And I'm sure a lot of you have experienced debt collection agencies to be very persistent and quite annoying. So in terms of small claims court, very quickly, we have a process whereby you would submit a statement of claim initiated by an applicant or a plaintiff. You have a defense filed in 20 calendar days by a respondent or a defendant, and then this is followed by a settlement conference and then a trial. At settlement conference, you won't have to provide any evidence, but you will have to try and see whether two parties can come to a settlement. Typically, I have known settlement conferences to work, but more importantly, it can proceed to trial. 30 days after your settlement conference is when you can set it for trial. A date can come from a year, 2 years from that point. Now, trial will generally generate an enforcement. Now, when we talk about debt collection agency, you have client authorization, followed by what is referred to skip tracing. Does anybody know what skip tracing is here? Skip tracing, guys? Anybody?
Some people are not available online or something.
True. Yeah.
How to come to connect, how to get their phone number or email address.
Right.
That is.
Right. A skip tracing process is typically performed by a private investigator or a process server who actually traces down the address. Because in a statement of claim, or in the case of a debt collection agency, you're going to want to know the full name of the person, because nicknames don't work. So you would have to have a full name and a number or an address, a residential address. And so skip tracing helps you with it. And it's a very, very cost-effective process. Then you have the persistent agent that continues calling once everything is set up and then payment is received, okay? So that's the debt collection agency. Now, as far as paralegals are concerned, we are not permitted, or it's not in our scope of practice, to actually collect the money for you. So we are able to partner with agencies, a debt collection agency, to offer debt recovery services. The agency works with a sub-client agreement, so we would, we would resource them to sign all the agreements, the skip tracing process again, and then highly motivated because everything is essentially commission driven. So the results are fairly quick. So what are we looking for timelines for remedy? I'm sure most of you have heard of mediation, which is the absolute process that I'm going to recommend you go with tonight. It's early resolution, where two parties are contacted by a third-party facilitator like me, or a neutral and unbiased party like myself, and we come to a resolution. I had a client that I retained only this week who has a debt, credit card debt of, well, the debt at the time the cap was $7,500. Within a short 2 weeks, that debt has gone to $9,800. So someone like Capital One will not negotiate with you if you call their number. They will not negotiate with you. However, they will negotiate with a licensee like myself. And therefore, there are two options that were offered to this particular client. So one of the options was a payment plan. They were only offering him $1,600 per month to cover the $9,800. And that was over 2 years, including interest. When I spoke with them, they were willing to put in a payment plan of $250 over 5 years. And then anybody could come in and make a payment. If you had a $2,000 refund, you want to put it towards that debt, it would certainly, help a little bit with the credit score. But the other option was I was able to negotiate from $9,800 to $7,500 with a $1,250 payment per month for 6 months. And it would clear out the debt, and he could borrow that money, and his credit score would be restored within a few 6 months, okay? So it certainly helps to have mediation and early resolution part of your plan. The other thing is small claims court. After the pleadings process, that can count for about a 1 to 2 month. You have a default judgment that can be given to you 21 days. That's the beauty of a small claims court process. Because if the defendant doesn't respond to you, you have the option of going with a 21-day default judgment. And if you get it, that's very lucky. Settlement conference can take a couple of months. In the small claims rules of procedure, you should typically receive something in 90 days. The courts are so backlogged, it takes now about 14 months on average to get a settlement conference. After which time, you have, if you're not successful at a settlement conference, you have a cooling period for 1 month, and the trial can take up to 1 or 2 years to set. So now we're looking at 2 years in total, okay? Debt collection agency. Once the client gives you authorization, you can take up to 1 to 2 weeks. The agent calling efforts depends on the cooperation from the debtor, and it can take a few weeks to over a year. And settlement can take up to 2 weeks to 1 month. So we're looking at a short 6 months if you want to see a portion of your debt, provided, given back to you. So what else can I help you with? I can help you with landlord and tenant board representation and form filling. I can help you with contract and document review and drafting. I can help you with notary public services and commissioning. and I help with various mediations and third-party facilitations. And so I highly recommend all of you speak to me today with respect to any early resolution aspect that can help your legal matters. Now, I just wanted to give you a quick summary on notary public services versus commissioning. The top most documents that usually get notarized are travel consent letters, power of attorney documents, real estate closing documents, certified true copies of original documents, and the ones that are commissioned are sworn statements, affidavits for courts, statutory declarations, government forms, and insurance claim forms, okay? Now, today I'm here, guys. Come and see me. I'm at the booth, and I am more than happy to speak to you about any preliminary matter, and you can learn more about from me. And I have a gift basket there, so I would love to get your business card in turn, and also have some really nice information in the event that you want legal aid information, or 30-minute session with the Law Society of Ontario Referral Network. So thank you for listening to me today, and I hope to help you, okay?